Good morning, Your Honors. My name is Marlon Kirchhoff, and I'm counsel for the appellant, American Association of Physician Specialists. And I would like to reserve the full 5 minutes for my rebuttal, please. If you're ready to begin.
Please.
Good morning. This appeal is about a motion to dismiss that was granted erroneously. It was granted erroneously because appellant, American Association of Physician Specialists, to whom I shall refer to as AAPS, more than adequately pled sufficient facts to show proper jurisdiction over Patricia Stewart, one of the party who, again, for whom the motion was granted. Not only did AAPS plead sufficient allegations to have jurisdiction over Dr. Stewart based on her personal conduct, but they also pled sufficiently to have jurisdiction over her for the conduct of her agent, her husband and attorney Bill Okerboom, but also pled sufficient facts to grant jurisdiction based on her being part of a conspiracy, which also itself was adequately pled. Each of these allegations alone is more than sufficient in and of itself to allow the courts in Florida to have jurisdiction over Dr. Stewart, who is a California resident. As this is a de novo review, the court will use the same standard as the lower court on a motion to dismiss. And it's important to remember that only one claim needs to be sufficient in order for the entire pleading to be sufficient. And the court is limited to the four corners of the pleadings and must accept them as true. A short and plain statement of the ultimate facts showing that the pleader is entitled to relief is more than enough. Additionally, the pleading clearly comports with Florida's long-arm statute, which asks, do the pleadings establish sufficient jurisdictional facts to subject a non-resident to long-arm jurisdiction? And does this non-resident possess sufficient minimum contacts to satisfy constitutional due process requirements? We will show you that, in fact, those requirements have been met, because it's very clear that the actions of Dr. Stewart, both on an individual basis and via her agent's actions and via her conspirators' actions, were clearly directed towards people and organizations in the state of Florida. And therefore, Dr. Stewart should have a reasonable expectation of being hailed into court in Florida to answer for those actions.
Because,
yes,
is it, and I recognize this is what your argument is, but can we agree that she does not live in the state of Florida, correct?
Absolutely.
All right, and then can we also agree that she does not conduct any business in the state of Florida?
Absolutely correct.
All right.
But nevertheless, her actions are the classic kind of actions where a party from an outside state directs their behavior towards a particular state, in this case the state of Florida, and causes damage to people and organizations in the state of Florida.
Let's walk through something here. You've got your allegations in the complaint, and then Dr. Stewart filed, I think, probably multiple affidavits stating that, denying the jurisdictional allegations, the facts upon which you base the claim that there's jurisdiction over her. Did AAPS ever file affidavits that contradicted the affidavits that Dr. Stewart filed?
Well, I have two responses to that, Your Honor. The first response is that while Dr. Stewart did in fact file an affidavit that she claims rebuts the jurisdictional allegations of the complaint, if you actually look at the affidavit, it does no such thing. The affidavit is full of either...
Before you get too far off, what's the answer to my question? Did AAPS ever file
AAPS did not file
affidavits?
I'm sorry, AAPS did not file any affidavits for two reasons. One, the affidavits that she submitted did not sufficiently shift the burden to AAPS to have to file an affidavit. And two, it's clear that the allegations of the complaint, with the documents attached to the complaint, are sufficient in of themselves to establish jurisdiction.
Under the Venetian salami procedure that the Supreme Court laid out, she files her affidavits denying the allegations of jurisdiction, and then it's up to the plaintiff to file counter affidavits, and then the court can the court can resolve the matter based on the affidavits. It can go ahead and rule. If not, court's supposed to conduct an evidentiary hearing. But here, it seems like we never got beyond the first step of Dr. Stewart filing the affidavits denying the allegations of jurisdiction. AAPS never filed anything to contradict that. How under that procedure and that analysis did the trial court err in granting the motion to dismiss?
Quite simply, Your Honor. First, the Venetian salami procedure only requires rebutting affidavits in those instances where they're necessary. It does not require an automatic filing of a rebutting affidavit when the actual affidavit itself is contradicted by the documents attached to the pleading and itself does not meet the standards necessary to shift the burden. That is how the court erred. If you look at Dr. Stewart's affidavit, there is nothing in there specifically. The rules require that an affidavit filed to challenge jurisdiction cites specific factual things that rebut the jurisdictional allegations. If you look at Dr. Stewart's affidavit, it has no such things. It's full of general denials. I never defamed anybody. I always had good intentions. It's full of defenses that are not proper on a motion to dismiss. I'm privileged. This was an act of goodwill. This was done with due diligence. All these things are great, and they may even in fact be true once the evidence plays out, but none of them actually meet the standards required. None of them actually rebut the factual allegations, that she filed the things she filed, that she told people to do the things that they did, that the actions that happened were not only taken by her, but with her consent by others. In fact, she even admits in her affidavit many jurisdictional aspects. She admits that Dr. Okerbloom was her attorney. She admits that she directed him to do things, and he admits in his affidavit that she adopts by reference into her affidavit that he, in fact, did things and directed them into the state of Florida. And
But doesn't she also indicate in her affidavit, I guess my question follows Judge Wallace's question. Her affidavit categorically denies a lot of things. She even categorically denies that she never assisted or advised her husband. So that kind of creates, this affidavit is out there. Shouldn't that, at that point in time, the AAPS filed an opposing affidavit, which then would trigger the evidentiary hearing for the court to resolve those issues?
I think not, Your Honor, and I'll tell you why. For example, her claims, the allegations, the facts, so to speak, in her affidavit are just conclusory statements. So when she says, I didn't hire my husband, AAPS is in no position to put an affidavit saying that she did hire her husband. We haven't done discovery, we don't know. But we do have attached to our pleading a legal opinion by her husband, and it says, attorney for Patricia Stewart. And that is documentary evidence that clearly rebuts her conclusory statement that I never hired him. I didn't have any bad intentions. He was acting not at my behest. Well, guess what? The documents say he was acting at your behest. And you admit in your own affidavit that he was acting at your behest. You say that you asked him as your lawyer to go do things. He does them. The documents say he's your lawyer. So therein lies the point. There is no need to put in these affidavits when there's documentary evidence rebutting it. And when the affidavit itself is full of nothing but blanket categorical denials. Saying I didn't defame anybody is not refuting a specific jurisdictional fact contained in the pleading. And therein lies the problem with her affidavit. And if you look at the pleading, it clearly indicates that she, number one, filed a defamatory filing with the court. Initially, when Dr. Stewart made her motion to dismiss, along with her husband, Dr. Okerbloom, who also we are suing in this case, it was a narrow jurisdictional motion. They were claiming that there was no jurisdictional grounds to bring them into the state of Florida. That's a very narrow argument. As part of their filings for this very narrow jurisdictional argument, they filed all sorts of other things that were defamatory, accusing people of being child pornographers, racists, all sorts of things. Things that clearly had nothing to do with their jurisdictional filings.
So is your argument then that Dr. Stewart's affidavits were insufficient to trigger any obligation by AAPS to file a counter affidavit under the applicable procedure?
A little bit more than that, Your Honor. Not only was it not sufficient to trigger, but given the documents and allegations contained in the actual pleading, they were sufficiently rebutted by those things because they're factual. They're part of the four corners of the complaint.
But the complaint isn't sworn to. I mean, we can't take the allegations in the complaint as a given just because they're in there.
Well, you are supposed to take them as true on purposes of motion to dismiss. So the assumption is that it is true. So you have to take them as true.
For the purpose of a motion to dismiss based on the sufficiency of the complaint, but not as to the sufficiency of the jurisdictional allegations if they're contradicted by affidavit.
I would argue, Your Honor, that that is not the case if there's documentary evidence attached to the complaint that clearly establishes something counter to the facts of the affidavit. And also, again, going back to your point...
The documents aren't authenticated. They're not in evidence.
I understand, Your Honor, but the documents are clear and they're taken as true. And again, the affidavit also did not create a burden to rebut because there are no allegations in that affidavit that consistently and clearly rebut the specific factual allegations of the pleading. It is nothing but blanket denials and arguments of defense, affirmative defenses, things of that nature, none of which have anything to do with jurisdiction. Merely saying, I did not defame anybody is not a jurisdictionally specific fact. It is just a blanket denial. Saying, I didn't do anything to anybody in the state of Florida is not a specific allegation that counteracts jurisdiction. It's merely a blanket statement with no support, legal conclusory. And the case law is very clear. A affidavit of this type must be more than mere conclusory allegations. And that is why, for example, the supplemental authority filed by Dr. Stewart's counsel late in the game is an apposite, because in that case, that person had very clearly, as the court noted, pled specific facts that potentially defeated jurisdiction, something Dr. Stewart clearly did not do in this case. And so it's important to look at that fact that there are specific pleadings. Dr. Stewart herself filed this pleading that was defamatory. It's public record. She admits to filing it. It's a public record. She filed it. She admits to filing it. That is the basis of the personal jurisdiction purely as to her. There are the acts of her husband and counsel, Dr. Okerbloom. Dr. Okerbloom.
When you say she filed a defamatory statement, where are you saying that she filed it?
In the court, Your Honor. The litigation privilege doesn't extend to those filings that are wholly irrelevant to the subject matter of what is being filed. So there is a fairly high bar that protects people from defamation claims and abusive process claims based on court filings. But that bar only goes so high. That bar stops when the materials are wholly irrelevant. And our argument is quite clearly that in filing a motion where you say there is no jurisdiction against you by the state of Florida, that has nothing to do with, in the meantime, calling people child pornographers as part of your filings, amongst other things. And so it is the extra thing she put in her affidavit. I think calling somebody a child pornographer is about as offensive as one can get. And there's clearly no connection between labeling people as child pornographers and the state of Florida having jurisdiction over her.
Is the argument then that there was no personal jurisdiction when the lawsuit was filed, but she did things that caused jurisdiction to arise after the action was filed?
Not at all, Your Honor. The argument is that before the lawsuit was filed, the jurisdiction was based on the acts of her agents, Dr. Okerbloom, her attorney, and on the acts of her co-conspirators. However, after we filed the initial pleading and she filed the motion to dismiss and put in these extra things, when we filed the new version, we added that as part of the claims. But there was always jurisdiction over her because the actions of your attorney are always your actions. Your attorney is clearly your agent, and when you hire an attorney and direct him to go do things, you are responsible for the things he does.
Well, you know, as I recall Dr. Stewart's affidavit, and maybe I'm not remembering it accurately, but it seemed to me that her claim was that she had authorized Dr. Okerbloom, or whatever his name is, to do some things that were relatively limited and that took place in the state of Virginia and that after that, any things that he did were done on his own and not on her behalf. So I don't, if that's true, and if that's what she said, I don't know how that gets you to jurisdiction in Florida.
Well, Your Honor, first of all, it's very clear that he was her attorney. The action in Virginia was when he published a so-called legal opinion that Dr. Stewart then put on the chair of every individual, at this delegates meeting.
Virginia?
In Virginia, yes, Your Honor. But then Dr. Okerbloom went on to take steps that she claims, first of all, Dr. Okerbloom admits to then sending that opinion via email to people in Florida. He admits it in his affidavits, which she incorporates by reference. So let's start with that. First off, he took that opinion.
I should tell you you're at 15.
I am. Now I'll reserve the rest for rebuttal. Thank you.
Good morning. May it please the court. My name is Jim McGuire. I'm here today with my partner, Mark Caramonica, and we represent the appellee, Dr. Patricia Stewart. Your Honors, in some ways I'd like to adopt the line of questioning you've just asked, because I think the things you're asking are precisely the argument we want to make today. Dr. Stewart had essentially no connections with the state of Florida prior to being sued here. She didn't send any emails here. She didn't send any letters here. She didn't place any telephone calls here. She didn't post anything on a website that could be accessed here. She did nothing in the state of Florida. She then gets sued and defends herself by saying, I'm not subject to personal jurisdiction here. And they turn around and say, well, now you are, because you defended yourself and you said you're not subject to personal jurisdiction. I mean, the argument is remarkably convoluted, and I sensed some questioning or concern about the argument that simply by defending yourself and raising jurisdictional arguments in Florida, that in itself would subject you to personal jurisdiction here. Obviously, it does not. And that abuse of process claim, which I'll discuss a little bit further, frankly, on its face, fails, could not possibly state a claim for a tort committed in the state of Florida. But, Your Honors, the argument I've been hearing this morning is that AAPS, or I sometimes call them APS, it's just easier to put it that way, that APS sufficiently pled jurisdictional facts, and that my client, Dr. Stewart, in her affidavits, didn't do enough to shift the burden to them. That assertion is just plainly wrong. If you go through their complaint in detail, and go through their complaint as opposed to their appellate brief, because they're two very different documents. The appellate brief says, oh, we allege that Dr. Stewart sent something into the state of Florida. See this site. Go to that site in the record and see if it says that. It does not. The third amended complaint does not contain a single allegation that Dr. Stewart or her agent did anything in the state of Florida. The only thing it alleges that she did in the state of Florida is to defend herself with respect to these jurisdictional claims. So, you know, we're talking a little bit this morning about burden shifting. In fact, the burden was never even on Dr. Stewart to come forward with affidavits, because APS failed to allege personal jurisdiction. But despite that fact, Dr. Stewart did come forward with affidavits and address the specific allegations as we've discussed this morning. Yes, I asked my husband to prepare this initial opinion, which I circulated in Tyson's Corners, Virginia, and that was the end of it. At that point, I was done, and Dr. Okerbloom puts in his own affidavit that says, the things I did later on were on behalf of other doctors associated with APS, not my wife. So that issue is addressed in a very straightforward way in these affidavits. And has been asked this morning, well, the burden's now on APS. What did you do? How did you counteract that? They didn't do anything. They sat on their hands and said, we're not required to do anything. That's wrong. Florida law does require them to do something. The burden shifts. Now, Your Honors, I was, just to be clear, my partner and I got hired for the oral argument here. We're not involved in drafting the brief. So, you know, there's some details of what's in the third amendment complaint and what's not that I'd like to go through with the court if it makes sense, but I don't want to rehash things that the court is already aware of. But I've stepped in sort of late in the game, and that's the reason for that approach. As I read App's appellate brief here, they basically argue that there were 5 publications that were sent into the state of Florida by Dr. Stewart through her agent, Dr. Ackerblum. But if you go through each and every one of those, the allegations simply aren't there. The first, as I just mentioned, is this so-called defamatory opinion, which was the initial investigation which was circulated in Tyson's Corner, Virginia. If you look at the sections of the Third Amended Complaint that discuss that, it does say the document ultimately was disseminated in Florida, but it doesn't say by whom. That's not an allegation of personal jurisdiction as to Dr. Ackerblum or Dr. Stewart. It also says that the defamatory opinion was accessed by email, but it doesn't say who sent those emails. What APPS does throughout this brief, and they've got talented and experienced attorneys here, so you have to wonder what the thinking is. They make these statements about documents appeared in Florida. They're always in the passive voice. They never allege Dr. Stewart sent this document into Florida, or her agent, Dr. Ackerblum, did it. They simply don't make those allegations. And as mentioned a moment ago, even to the extent that those allegations are sort of out there in the atmosphere, Dr. Stewart denies them in her affidavit. She says, I gave it out in Tyson's Corner. No one else testifies that they ever sent it into the state of Florida. The second publication is what they're calling the defamatory letter. It's a letter that Dr. Ackerblum wrote in December of 2011. His affidavit very specifically says, I was requested by several doctors to send warning letters to the House of Delegates. My wife was not one of them. Combine that with her affidavit saying, after the initial investigation, I withdrew from the matter. Well, we now have factual denial that the second letter was sent into the state of Florida by anyone associated with Dr. Stewart. But again, that affidavit isn't even necessary because the Third Amended Complaint, again, has this sort of passive voice allegations. The letter made its way into the state of Florida. That's not an allegation that anybody did it. If somebody who was at the meeting or was in New York State got a copy of the letter and traveled down to Florida and brought it here, the letter may have made its way to the state of Florida, but that doesn't subject Dr. Stewart to jurisdiction here because she didn't send it into the state of Florida. She didn't commit a tort in the state of Florida. Your Honor, the same thing with respect to the 3 other publications that they mentioned. There's the defamatory email, the second defamatory email, and what they're calling the defamatory website. With respect to each and every one of those, the Third Amendment Complaint contains not a single allegation that Dr. Stewart was involved with them or published those materials into the state of Florida. Again, there's some passive voice, somebody in Florida saw it, but no allegation that my client did it. And more to the point, Dr. Stewart in her affidavit says, I had no involvement whatsoever in the second email, the first email, the defamatory website. I've never even been on the defamatory website. So all of these failures of pleading and then affidavits saying, I think I understand what you're getting at, but I'm telling you it's not true, the burden absolutely was on APPS at that point to come forward with something, and they didn't even attempt to do so. So the agency argument, I think, fails as a matter of pleading, and it fails as a matter of evidence. Because they can't get there through agency, the next effort is to say, well, Dr. Stewart is a part of this huge conspiracy. Everybody's out to get us. And she's one member of that, and some of those people in the conspiracy did some things in the state of Florida. Therefore, she's subject to jurisdiction as well. Well, Your Honor, again, that's an argument in the appellate briefs. It's not in the Third Amended Complaint. The conspiracy claim is count 2 of the Third Amended Complaint. And it's at page 1361 of the record. Each of the paragraphs in count 2 of the Third Amended Complaint says, essentially, the counter defendants, that's Drs. Castillo, Geller, and Klein, non-parties Bell and Newby, those are 2 people who haven't been sued here, and co-conspirators whose identities are unknown, took the following acts. That litany of the involved parties in the conspiracy is repeated again and again and again in count 2 of the complaint. No mention of Dr. Stewart. No mention of Dr. Ackerblum. Now, there is one sentence in the summary of count 2 that mentions Dr. Stewart. And that sentence says that Dr. Stewart acted ultra vires. I don't know whether she acted ultra vires or not, but that's not an allegation of a conspiracy. A conspiracy requires an agreement to do something unlawful. There is not a single allegation anywhere in the Third Amended Complaint that Dr. Stewart conspired with anybody. So again, this argument that she's part of this big group that's out to get us and to bring APS to its knees, and we've clearly alleged that, and she only gives sort of general denials of that, is simply a misstatement of what's in the record. Your Honor, since agency doesn't work and conspiracy doesn't work, we then get this abuse of process argument, which, you know, I'm hesitant to use the word frivolous, but it's pretty darn close to that. A case of abuse of process has three elements. You have to show that the defendant made an illegal, improper, or perverted use of process. The defendant had ulterior motives or purposes in exercising process. And as a result, the plaintiff suffered damages. Well, one of the things that the APS forgets to mention in their briefs is, what is process? Responding to a complaint with a motion to dismiss is not process. Process is a summons. Process is a subpoena. Process is a writ of garnishment or another special writ. That's what process is. That's why the cases say abuse of process is essentially a form of extortion. That's where you sue someone and drag them into court and drive up their legal bills and do all those sorts of things to enact some revenge on them, essentially. You use the legal system for something it wasn't intended for. That's abuse of process. They haven't come close to alleging that. They've alleged that she tried to defend herself. And then they say, well, yeah, there's lots of scurrilous material in her defense. But the abuse of process standard, even if that response was considered process, the abuse of process cases say, if the process achieves its goal, it's not an abuse. Well, Dr. Stewart filed a motion to dismiss for lack of personal jurisdiction, and the trial court granted the motion to dismiss for lack of personal jurisdiction, which means it accomplished its goal. And they plead that fact. So they plead that they don't, in fact, have an abuse of process case. And then there are numerous other problems with that claim. There's the fact that there's an absolute privilege for judicial filings. That absolute privilege has only one limitation. It says the filings must have some connection to the underlying matter. Well, yes, there's a lot of material in here about the dispute that's going on at APS, but that's what this whole case is about. This whole case is about the alleged mismanagement of this organization, not simply by incompetence, but by unethical behavior. And yes, so some of those issues are discussed in the motion, but those issues are raised in the original complaint and in the counterclaim. They aren't raised for the first time by Dr. Stewart in her papers. So the abuse of process claim fails on its face. It fails as a matter of law. They haven't alleged a single element of a conspiracy with regard to Dr. Stewart. They haven't alleged agency with respect to Dr. Stewart, except for the very first opinion that Dr. Ockerblom prepared for her. But they don't allege that was distributed in Florida by Dr. Stewart or Dr. Ockerblom. And in fact, Dr. Stewart and Dr. Ockerblom both say they didn't do it. They distributed it in Tyson's Corner in Virginia. So what you're left at the end of the day is basically a big fat zero in terms of personal jurisdiction. Nothing. They don't have a relevant connection with the state of Florida. They don't have any pleadings about connections with the state of Florida. And they have no evidence of any connections with the state of Florida. Your Honor, the trial court got this one right. We would ask the court to affirm the decision below. Thank you.
Your Honors, I'd like to address some of the things that were raised by opposing counsel. First off, it's also very clear that the appellate court found jurisdiction over Dr. Ockerblom for the acts he undertook. And then this panel, well, not this exact panel, but this court affirmed that finding. So it is not at all true that the allegations contained in the pleading do not address the things that they're supposed to address. In terms of the acts of Dr. Ockerblom, it's very clear what those acts were, and it's alleged that those acts were taken on the behest of his client and wife, Dr. Stewart. As far as conspiracy, it also is quite clear what acts were tied between Dr. Okerboom and Dr. Stewart and the other co-conspirators. The law is quite clear. Conspiracy can be alleged via circumstantial evidence. And the pleading very clearly alleges that Dr. Stewart had Dr. Okerboom conduct his quote-unquote investigation, which resulted in the publication of the defamatory opinion, that Dr. Stewart actively encouraged that this opinion was then emailed to people in the state of Florida, that the opinion contained information and documents that they could only have obtained from the other, the counter-defendants, as they're called, in the pleading, because the counter-defendants had senior positions at AAPS where they had access to documents that Dr. Stewart and Dr. Okerboom simply would not have. And it alleges that they got those documents and that information from these other people who very clearly committed acts in the state of Florida. It also says that...
Does that paragraph of your complaint say who emailed it into Florida?
I don't have the pleading in front of me.
I can go back and read it.
I apologize, I don't have the pleading in front of me. But my recollection is it very does clearly say that. It's very clear that it was emailed by Dr. Okerboom. Dr. Okerboom in his affidavits admits that he emailed it into Florida. And then he says, well, you know, on that thing I wasn't a lawyer, on this I was. There is a concept that we argue is called apparent authority. And that is when you grant authority and you allow it to go on, people can assume that person is your agent. Well, look at the facts that are being pled. Dr. Okerboom is her husband. He's her attorney by his own admission and in the documents that are cited. He is not a member of AAPS, and he's going out there and talking about these issues and emailing people in Florida, and it's normal and natural for people to assume that he has apparent authority. And the idea that his wife had absolutely no knowledge of anything he was doing, he was just out there doing it for others, and she had no idea, is ludicrous. She clearly allowed it to go on, and that is where the apparent authority comes in. She told people very clear, he is my lawyer. His document says I am her lawyer, and he then proceeded to do acts that he claims were done on his own, but the apparent authority was clear. It is very reasonable for people to assume that if the husband and attorney of a doctor who's a member is emailing them, that he's doing so on her behalf, especially when he himself is not a member. Had he been a member, that argument would make a lot more sense because people might assume that he's speaking for himself. But as someone with no horse in the game, he's not a member, why is he sending members emails commenting on member actions? And so it is natural and normal for a reasonable person to assume that when a non-member who has identified himself as the attorney and husband of a member, someone who circulated a quote-unquote legal opinion to people and threatened to sue them via email, it's only natural and normal for them to assume that this person is acting on behalf of his client and wife because he's not a member. Why else would he be speaking? He has no reason to speak absent a direction from his wife and client. Something that was self-identified, that he put himself out there, and she put him out there as well. And so it's important that Mr. McGuire, with all due respect, is not correct. The allegations are very sufficient. It talks very clearly in the allegations how all these people are connected. Dr. Okerboom admits to talking to Tim Bell prior to drafting his opinion. It's clear that they have information that could have only have come from other people in the case. It very clearly indicates how everybody's connected. And the way they're connected is Dr. Okerboom, at the behest of Dr. Stewart, reached out to all these people. And he took information from them, and he used it. And he used it under his patina of being a lawyer to cloak their position in some sort of legality. And he went out there saying he was her lawyer and continued to go out there. And the fact that he didn't every single time say, I'm her lawyer, is not necessary because once he as a non-member was identified as her lawyer, why else is he talking to people in the organization with whom he has no connection? He's not a member, he's not an officer.
The difficulty, though, is that it seems like, you know, you tell us that all these things are so obvious and clear, and if that's the case, it seems like it would have been a very easy matter in something that is heavily litigated as this thing has been to just, why not file the affidavits? Then you've got your evidentiary conflict, and judge can have a hearing and rule on all these things, and that's the problem.
I understand, Your Honor, except that isn't an issue because the affidavit wasn't sufficient, and the pleadings documents are sufficient to rebut them. And the court did find Dr. Okerboom, who, same pleading, same affidavits, they're incorporated by reference, no affidavits filed to rebut. court found jurisdiction over him. And I asked this court, how can he, the self-identified attorney for his wife, who did things in the state of Florida, how can the state of Florida have jurisdiction over him, the agent, and not have jurisdiction over his wife, the client? The whole thing is clearly makes no sense. And so I would say to you that based on the fact that jurisdiction was found over him, that's law of the case, and upheld by this court, how can his actions, the actions of her agent, her professed agent, her identified agent, how can he be subject for his actions and not his client?
As your time has expired a bit ago, we'll end it with a rhetorical question.
Thank you.